in a minute. There we go. In Daniela Selena versus James Bender, 2020 DM 392. The petitioner appears by Zoom along with her attorney, Ms. Mindy Wheeler. The respondent, is he in your office?
No, ma'am. It's just me today.
Okay. Does not appear, but appears through counsel, Ms. Brammer. And there's been a motion that's been filed. Today's just kind of a status, but basically, Dad has filed to modify custody and parenting time and then child support accordingly, requesting a week on, week off situation. The kids are 17 and 14, I believe. And so they're teenagers. And there's been a proposed permanent parenting plan. So unless there is a legal reason why this motion cannot or should not be considered, I think this is probably a case where I will ask that it go to domestic conciliation, probably with collaborative out of Andover. And I will tell you one of my thoughts, but I'll hear from both of you. But one of my thoughts is I need to know the kids' schedule, their thoughts, how things go at each household, their grades, their all of those types of things. So, I mean, I will expect, Ms. Brammer, that your client has exercised all visitation that he was entitled to and then some, and sort of has gone above and beyond if he's asking for shared. Now, I understand the response is mom's paid for everything. Mom is the primary caretaker, provider, organizer, and all of those types of things. And I looked at a number of cases. I have a case about every half hour, hour today. I think this is the one that the other thing I'm concerned about is mom's income. If she's not working, is relatively low. So going from $2,300 or so in child support or whatever it is now down to $6 is quite significant and would certainly change the kids' standard of living, I would imagine. But having mentioned those things and my thoughts and my belief that this is actually a very appropriate case for a potential investigation, certainly mediation, I want to hear from counsel, starting with you, Ms. Brammer, since it's your motion.
Yeah, one of the kids has actually turned
All
18 at
right,
this point.
guys. What looked like a routine family court status hearing quickly revealed a custody battle that could dramatically reshape an entire family's future. As the judge called the case, both sides appeared through a combination of Zoom and legal counsel before immediately confirming the matter at hand. The father had officially filed a request to modify custody, parenting time, and child support. His proposal wasn't a minor adjustment either. He wanted a week on, week off parenting schedule, a major change that would completely alter the children's daily lives. The judge wasted no time explaining why this request deserved careful scrutiny. With the children now teenagers, ages 17 and 14, Their opinions, school schedules, emotional well-being, and daily routines suddenly became central to the court's decision. Rather than rushing toward an immediate ruling, the judge signaled that a full domestic conciliation process would likely be necessary. She wanted a complete picture of how each household functioned, how the children were performing academically, and whether shared custody would genuinely serve their best interests instead of simply satisfying either parent. But then the conversation shifted towards something equally significant: money. The judge openly questioned how the proposed custody modification could dramatically affect child support and, more importantly, the children's standard of living. According to the information already before the court, the mother earned relatively little income. Reducing support from more than $2,000 each month to only a fraction of that amount could fundamentally change the financial stability the children had grown accustomed to. It was clear the court viewed those consequences as impossible to ignore. As the judge outlined her concerns, she emphasized that this appeared to be exactly the type of case requiring mediation and possibly a formal investigation before any permanent decision could be made. Rather than choosing sides, she wanted independent information about parenting responsibilities, household stability, and the children's overall circumstances. Only after laying out those expectations did she invite the father's attorney to explain why the requested custody modification should move forward. And that's where the legal battle truly began, with both sides preparing to defend completely different versions of what was best for the
Has
family.
actually turned 18 at this point,
That's true.
and graduated high school as well.
Okay.
So one of the things we wanted to accomplish today was to address child support, at least on a temporary basis, given that there's no reason for child support to continue for that specific child. And right now, my client's going to be paying for both kids until we have an order from the court. So I have talked to Miss Wheeler, and we haven't been able to agree on income. We did exchange some documentation and discuss what my client's income is, but we weren't able to reach an agreement on the figures. So we kind of came up with a temporary band-aid to at least like staunch the money bleed from my client's side to avoid significant arrears. And if I'm misstating, please correct me, Miss Wheeler, but basically we agreed to use the current reported income and insurance costs. Basically, the worksheet that's on file for the current costs, but removing one of the children. So we'll use currently accepted figures, but remove the eldest child. And we also couldn't agree on a commencement date.
I thought it's June 1.
Yeah, that's what my position is, but we had a disagreement about doing it on July 1st. That would be obviously my preference is June 1, but
Well, this is almost by operation of law that it terminates. But Ms. Wheeler, what is your position? It makes sense to me if you still need figures or you need to argue about imposing some kind of wage to mom, imputing it, that we at least look at where the last child support worksheet is and remove one of the children.
Your Honor, yes, Miss Bramer is correct that we had discussed entering a temporary order and reserving any disputes we may have about the numbers going into the calculation, but definitely removing the oldest child. Our position is that the new support date would start July 1st. Our reasoning for that is that the current order that's in place, and there have been several orders regarding child support filed in this matter over the years, and they have always maintained that it would terminate as of June 30th. It's specifically stated in the last child support order and all the prior child support orders that have been filed in this case. So my client was reasonably anticipating a termination of this support obligation as of June 30th. She does have costs associated with this child and the other child, and I would ask that the court make the temporary modification effective July 1st, and then if counsel can't agree, to make that effective June 1st, then we can take up that basically half a month's child support when we do have our final hearing in this matter. But I believe the last child support order, I don't have it in front of me, I apologize, was filed in mid 2025, and it maintained that same language that child support would terminate as of June 30th of the year the child turned 18 and graduated. And again, that's what my client was reasonably anticipating, that termination date for Brianna, the oldest child's child support.
Okay. Would you agree with me though that June 1st is usually, I need to look at the statute again, but isn't that statutory?
Yeah, I would actually have to go back and look at the statute as well, I believe. And I was discussing this with my client at some point in time and considering this, but I believe that in the
All
past
right,
it was
guys. The father's attorney immediately shifted the court's attention away from custody and toward child support. She explained that one of the children had already turned 18 and graduated from high school, meaning support for that child should no longer continue. According to her, the father was still being required to pay support for both children until the court entered new order. To avoid unnecessary financial hardship while the larger custody dispute remained unresolved, both attorneys had discussed putting a temporary solution into place. Although both sides agreed that support should now be calculated for only one child, another disagreement quickly emerged. The attorneys couldn't agree on the financial figures used to calculate the new amount, nor could they agree on the date when the adjustment should begin. The father's attorney argued that June 1st was the proper starting point, while the mother's attorney believed July 1st was more appropriate. What seemed like a difference of only a few weeks suddenly carried major financial consequences for both parents involved in the dispute. The mother's attorney explained that previous child support orders in the case had consistently stated that support for the oldest child would terminate on June 30th of the graduation year. Because those earlier court orders contained identical language, her client reasonably expected that same timeline to apply once again. She acknowledged there were still disagreements over income calculations, but argued that changing the effective date before the final hearing would unfairly disrupt expectations created by years of prior court orders governing the family's financial responsibilities. The judge carefully listened before questioning whether state law actually required support to end earlier than the existing order suggested. Even the attorneys admitted the statute might need to be reviewed more closely before a final answer could be reached. Rather than issuing an immediate ruling, the judge decided to reserve the issue for later consideration. For the moment, the court agreed only on one point: remove the oldest child from the worksheet and continue calculating temporary support for the remaining 14-year-old until the larger custody battle could be
But
resolved.
I believe that in the past it was June 30th because that's what I have always used until up through 2020 when we entered these orders originally. And
Okay.
I do believe that now, moving forward, we look more at June 1st as the obligation, the date to change the obligation. But my position in this case is that it has always been in the court orders as June 30th would be the termination date. And that's, again, what my client reasonably anticipated for support.
Okay. Well, I guess I just have to kind of hear some testimony as to why this, why there would have been some consideration given for something longer than the law provides for. But let's just reserve my ruling on that, see what you all can ultimately work out, but take the current order and remove the oldest child. So now we're just, for week on, week off purposes, we're talking about the 14-year-old. When does the 14-year-old turn 15?
That
I
would be
don't know that.
January. Sorry,
I'm
that would
sorry.
be January.
January.
Okay, so we got some time. So a freshman or going to be a sophomore?
Freshman,
Going to be a freshman?
correct.
Oh, so going into high school. And that's at Rose Hill?
No, that is Andover Andover Central is high school.
Okay,
Your Honor.
Andover Central, okay. All right. Okay, any objection to mediation with collaborative resources?
No, we had already talked about wanting to go to mediation anyway, and I don't really know anything about collaborative, but if it's what you guys always refer to, then that's where we'll go.
Well, I don't think we have a place anymore that is our go-to, always, like a standing order or anything like that. I think generally it's where the parties can agree for me, or I designate. But I do know they tend to do a very thorough investigation if there's not an agreement, including, visiting with children and that kind of thing. But so do a lot of the attorneys that do mediation. So I think for mom, it's going to be a matter of cost. So I guess I'll say, you guys either agree to someone, or my order would be collaborative resources in Andover. That's generally how I do it. I get attorneys to agree. If they can't agree, then I have to designate. But they do a good job of getting supportive documents or information. So I do think that they are worth the money, if you're going to be spending money on this anyway.
Okay. I'm fine with that.
Okay. So Amy, can we do the order well, I'll let them do the order when they decide for sure.
All right,
If there's
guys, with the temporary child support issue set aside, the judge redirected the hearing toward the child who remained at the center of the custody dispute. She confirmed the younger child was 14 years old and asked when the teenager would turn 15. After learning the birthday was still months away, the judge turned her attention to another important detail: high school. She wanted to know exactly where the child would be attending classes because school stability often becomes a major factor when courts evaluate requests for shared parenting. The attorneys confirmed that the teenager would soon begin high school at Andover Central High School, eliminating one potential conflict before it could develop. Satisfied that education wasn't currently being disputed, the judge shifted to another question that could shape the entire case. She asked whether either side objected to formal mediation through collaborative resources. Both attorneys responded positively, explaining they had already discussed mediation before entering the courtroom and believe it offered the best opportunity to resolve the custody issues without moving immediately toward a contested trial. The judge then explained why she frequently recommends collaborative resources in complicated parenting disputes. According to her, the organization conducts detailed investigations that go far beyond ordinary negotiations. Their process may include interviewing the children, reviewing school performance, evaluating each parent's home environment, and collecting supporting information that helps paint a complete picture of family life. Although acknowledging that mediation carries financial costs, the judge emphasized that spending money on a thorough evaluation could ultimately prevent even more expensive litigation in the future. With both sides expressing no objection, the judge instructed the father's attorney to prepare the necessary mediation order, along with the temporary child support adjustment, reflecting only one remaining minor child. However, before ending that discussion, another issue surfaced. Counsel requested firm deadlines to keep the case moving forward instead of allowing negotiations to drag on indefinitely. It was a request the judge immediately welcomed, making it clear that unresolved custody disputes should never remain in limbo longer than absolutely necessary, especially when children are directly
Side
affected.
for sure. If there's someone else that they can agree upon that they prefer. So, Ms. Brammer, I'm going to have you do the order for mediation, and then go ahead and do the child support adjustment order, please.
Also, Judge, can we get some hard deadlines in the case as far as a deadline for us to get mediation
Yes.
scheduled and in and then back in front of you?
Yes. Well, I always prefer to do them before school starts, but for sure 90 days. I'm always of the opinion that if an agreement can become, if they can come to an agreement, it can happen within 60 days, 90 days at the most. Otherwise, they're not agreeing to anything, and more issues, the longer they're in mediation setting, the more issues that get brought up and the more issues that develop, and it's not very productive at some point. So I would say let's check how things are going in August. I have a domestic day August 11th. That's not quite 60 days, but close. That's the first day of school, I guess, in El Dorado. I don't know about Andover, but there's no issue. Again, I'm sorry. Sometimes these cases run together because I have one case where mom's living in Rose Hill and there was some issue with that. But there is no issue with what school the child's going to go to in the fall, correct?
Correct, Your
No.
Honor. One up, if I could, if I may.
Daniela,
Yes.
I'll answer.
Okay.
Thank you. No, there's not an issue with the school choice. The school at this point in time, that's not been raised, changing the child's school.
Okay. All right. So it's not like we have to have something done before school starts, which a lot of these cases, it seems to be an issue. So what about the 11th? August 11th work for either one of you? If not, what I would be looking at is the 31st of August. So those are your choices, the 11th or the 31st.
August 11th works for me.
Works for me as well, Your Honor.
Okay, I only have settings at 1 and 2. So do you want to do 9 o'clock in the morning again? Does that work well, or a different time?
I mean, the afternoon's fine. If those are the only settings you have, I'm not picky.
No, I mean, I only have 2 already set that are taken up, 1 to 3. Otherwise, I have all morning,
Oh, okay.
3 to 5 open right now.
Gotcha. Okay. 9's fine if it's fine with Miss Wheeler.
It's fine with me.
Okay. All right, we're going to set this for review on DC on August the 11th. Are there any other dates that you would like, Ms. Brammer?
Getting scheduled within the next 30.
Do what?
A requirement that we have something scheduled within the next 30 days.
Oh, I'd
With
like to
the
have something
DC.
scheduled in the next 2 weeks.
Next 2 weeks. Okay, that's better for me.
Yeah, that they
I'm
make
trying to keep it rolling.
with whoever you guys have agreed upon, or in the alternative, the one that I mentioned, if you can't. Okay?
Yep.
All right. If there's nothing further today, we are adjourned. Thank you.
All right, guys. The hearing entered its final stage as the attorneys pushed for a clear timeline instead of leaving the case open-ended. The judge agreed, explaining that custody disputes involving children should move quickly whenever possible. In her experience, if parents couldn't reach common ground within 60 to 90 days, extending mediation usually created even more disagreements instead of solving existing ones. Rather than allowing the conflict to drag on for months, she proposed setting a firm review hearing so the court could closely monitor the family's progress. The discussion then turned to scheduling around the upcoming school year. The judge noted that many custody cases become urgent before classes begin because parents often disagree about school placement or educational decisions. This case, however, was different. Both attorneys confirmed there was no dispute over where the teenager would attend high school in the fall. With that important issue already resolved, the judge concluded there was no immediate need to rush the case solely because the new academic year was approaching. After considering several possible dates, the judge proposed an August review hearing and asked both attorneys whether the schedule would work. Without hesitation, both sides agreed that August 11th would be acceptable. The judge also discussed available hearing times before everyone settled on a morning setting. Although these scheduling details might have seemed routine, they reflected the court's determination to keep the custody modification moving efficiently rather than allowing unnecessary delays to interfere with the family's future. Before adjourning, the father's attorney requested one additional safeguard, a requirement that mediation be scheduled within the next few weeks. The judge agreed without hesitation, tightening the deadline even further by encouraging both parties to arrange mediation within just 2 weeks whenever possible. With those final instructions placed on the record, the hearing officially came to an end. But the real battle was far from over. The difficult questions about shared custody, parenting responsibilities, and the teenager's future would now move into mediation, where both parents would have one more opportunity to resolve their differences before returning to court.